The Honorable, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
All right, thank you, Mr. Horn. We are now in session for our WebEx argument, the case of Blanchard v. Blanchard. I'll just briefly introduce our panel, and I'll also have our judges say hello just to make sure their video is all working properly. I'm Judge Donna Stroud, and also on our panel today we have Judge John Tyson. Judge Tyson, if you would just say hello so we know your video is working.
Hello, everyone.
Okay. And we have Judge Allegra Collins.
Hello.
All right. And so we are now ready for argument from the appellant. And Ms. Watts, if you're ready to proceed.
Thank you. Good afternoon, and may it please the court. My name is Rebecca Watts, and I represent the defendant appellant, David Blanchard, and I would like to reserve 5 minutes for rebuttal. As this court has said several times, the distinction between civil and criminal contempt is hazy at best. And although that distinction may be hazy, there are enough differences between the two that an alleged contemptor, before he walks into the courtroom to defend himself, ought to know which he will face, civil or criminal. When Mr. Blanchard's trial attorney made this argument to the trial court judge before the contempt hearing, the judge's response was that she attempted the way Mr. Blanchard's attorney was attempting to undo the way we do contempts in North Carolina, and that there's no rule you have to choose, that the moving party has to choose. In other words, this is how we do it. In discussing why the moving party might want that flexibility, Appellee's trial counsel noted a desire to keep things open. In case, for example, someone came into compliance before the hearing, and if you had chosen civil, then now you're stuck because they're in compliance, you can't do criminal. Unfortunately, this approach where a moving party can just throw everything out there and let the trial court sort it out, and that's requiring your alleged contemptor to more or less prepare for court as if he's preparing to hit a moving target while blindfolded. And it's our proposition that this failing to give notice to him before the hearing starts does not provide adequate due process protection. And I just want to say one thing we're not asking you guys to do, and because Appellee raised in their brief that they thought our proposition was that when you have civil and criminal, the hearing has to be bifurcated. That is not what we're arguing. That's not what we argued in our brief. And the bifurcation would then have to do with how the hearing is conducted. We're a step before that. What we're arguing is before you even get there for the hearing, you've got to know what kind of hearing you're doing. How the hearing would be done with civil and criminal, if it needs to be bifurcated, that's kind of an interesting procedural issue, but we don't have to deal with that to deal with this. So what we are asking you to hold is that when there are allegations in a contempt motion, whether it be 1 or 6 or 20, that due process to the alleged contemptor requires that he be provided with notice for each one, the type of contempt sought. We believe this notice should be provided on the same timeline as notice of hearing. That is to say, if you have a contempt motion with no show cause order, you're required to give somebody at least 5 days notice before the hearing that they are going to come in and be heard on contempt, to defend a contempt motion. If you have a show cause order,
let me interrupt you for a moment and ask a question. Because I don't believe we had a reply brief, and so I was just wondering, in Ms. Blanchard's brief, they note that the failure to appeal from the order to show cause or the order denying continuance that there was no appeal from those orders. And, they contend that we would not have jurisdiction to consider this because there was no appeal from those particular orders. What's your response to that?
Well, he's correct. We did not appeal from either of those. The continuance order, I think the continuance motion was simply to allow the trial court time to hear the motion for more definite statement before the contempt hearing, and the trial court dealt with that at the beginning of the contempt hearing. So whether or not it was continued really had no bearing on anything. The continuance was, please let us answer question 1 before we get to question 2. And the show cause order, we're not saying that there was a per se problem with the show cause order. Statute said it has to be served at least 5 days ahead and notify that you could be held in contempt. And it was served probably well more than 5 days ahead of the time. I'm not sure when it was actually served. Our argument is not that the show cause order has to specify what happens for each allegation. Now, that would be a convenient place to put it, but that's not what we're arguing. We're arguing that the denial of the request, whatever form that was in, to be advised and to start a hearing, I think at 9/11 for a docket that started at 9, he was informed of which allegations of the 6 were being pursued that day and how they were being pursued, that's a due process problem. I could have appealed the show cause order and come at it from a different direction, but that was not what we were arguing about. So, about the procedure of the contempt hearing itself. Does that answer the question? Okay. Thank you.
A question.
Okay.
So if the answer had been, we are pursuing all 6 allegations on both criminal and civil grounds, would that have given notice? Would that have been sufficient?
And I think he said if the response had been, we're pursuing all 6 as both, well, they can't pursue the same.
Okay.
Yeah.
So it's just one, they gotta choose one or the other. So by choosing. Okay.
If they said the first 3 allegations we want civil, 4, 5, and 6 we're going to pursue as criminal, and we'll sort that out. We'll sort out how we do that hearing. But yeah, if they had said this is what we're doing, but the response was, well, we don't have to tell you, or we don't know yet, and that's kind of a problem. As I mentioned, Appellee's trial attorney talked about wanting to maybe switch once they got there. If somebody was if I lock myself into civil and they're in compliance, and why in the world would anybody ever come into compliance? And if I come into compliance, now I'm not in civil contempt, but now I could be held in criminal contempt. Why not just come to court and have your hearing on civil?
I thought that was an interesting sort of rhetorical question in your brief. Like, why would you come in compliance?
Right.
And I think we all have done this long enough to know, as a practical matter, how the game is played sometimes in these cases, especially when you're dealing with a continuing, it's easy with money things.
Right.
It's a lot more complicated with things like these visitation provisions and contact and communication. Things that are going to be happening over and over and over and continuing. And obviously any particular day, once that's over, it's over, but we've got tomorrow coming. And so that sort of sets someone up for a situation where he could say, well, okay, fine, I'm going to continue to do this. I'm going to not allow mom to communicate. And then 2 days before the hearing, I'm going to say, oh, here you go. I've got it all fixed now. Now I'm not in contempt. And then the motion goes away. And then 2 weeks later, he does it again. And then again, and then again. And this is the thing that drives judges crazy and people. Which is, I think, the reason that it's left open.
If it is an ongoing thing, like the first time, sure, somebody comes into compliance, you still got the specter of attorney fees, assuming you've had a show cause order. Well, you've come into compliance, but we had to drag you in here kicking and screaming to make you comply, an hour ago. You're still going to be responsible for bringing us here. And then the next time it happens, the next time, if it continues to happen and there's a, 11th hour compliance, I could definitely see saying, you know what, we're pursuing criminal contempt, period. We know we're not going to get attorney fees, but we're pursuing criminal contempt because we're not going to mess around with you complying at the last second anymore. But that is multiple. This was one motion. The first time this motion was on for hearing.
It's one motion, but it was a long period of time that this was continuing over with, according to the order, I think, like 7 letters from the lawyer saying, we're having this problem, we're having this problem, we're having this problem, with her attempting to communicate and fix it, not being able to. And so when all that fails, you end up in court. So, would someone have to prove that, we've been to court 4 times? Or would it be enough to show that this has been going on and on and on and on for weeks, despite numerous requests, it hasn't gone away?
I'm not sure I know what the question
I'm just saying, would that be sufficient? Because you said, well, if it's happened over and over and they've maybe not been held in contempt before, they have to be held in contempt before. Or if it's, now obviously if it happens once, if last Saturday I didn't get a phone call and I magically get back into court, the very next week, and it's happened one time, that would be silly. But, or you have a pattern.
Well, I think where you have a pattern, I wouldn't necessarily have to say, well, you have to have a pattern. They've been found in contempt because, they've not been found in contempt, but they have the pattern of playing this game where they're doing this. And then that justifies, perhaps criminal the second time or the third time that something like that is going on. That's not a one-time sort of payment thing.
Mrs. Watts, let me ask you this. Is there any difference in the conduct of an individual that would qualify for civil or criminal contempt? Put another way, can the same conduct qualify for either?
In many cases, I think yes. And one thing Apolli said in her brief is we ought to have figured out that this FaceTime issue was civil because they mentioned the ongoing nature of it. But it's really not that straightforward, especially in family law cases. I mean, if you have a case like Judge Stroud mentioned where you don't pay that check, well, that's pretty easy. I can do civil contempt and you hand me that check. But I could also hold you in criminal contempt and say, I want you to be put in jail for not giving me that check. So I think a one-time thing like that could be pursued as either. If it's something like, I didn't make a custody exchange last weekend, can that be civil? I don't know. Can you make somebody go back and comply with an order telling them to do something last weekend? Maybe not. Maybe that has to be criminal. But
well, if it was one and the same, why would we have 2 different types? That's my point. If the same conduct can trigger either one, there has to be a legitimate difference between actions that would constitute criminal contempt as opposed to actions that would constitute civil contempt. I realize the remedies are different. I realize that the purge is different. But if it's one action can constitute either, what are the differences between the two? When can you have one and not the other?
My opinion is when you have something that is in the past and you cannot force somebody to do it because the time is up for doing it, that it can only be criminal. Like it didn't make the exchange last weekend. My opinion is that can only be criminal. I know it's sometimes the judge holds somebody in civil contempt for that, but there's no way to remedy that by compliance with the order because the time's already passed.
So if the performance is executory, meaning not complete, and some has to be done in the future, that would be subject only to civil contempt? If there's some performance remain to be due?
I think so, yes, for something that is to be done in the future. I think most of the time we're looking at civil and family law cases, and quite honestly, because you don't have attorney fees as an option for criminal. And if somebody's going to all the trouble to bring somebody in for contempt and to want them to comply, they're usually going to bring it in as civil. Otherwise, you know, you don't get somebody to hand the child over, you don't get the check, and then somebody goes to jail and you've paid a bunch of attorney fees. So most of the time it is going to be there as civil. But I agree that family law has a lot of fuzzy actions that you could make a legitimate argument that it's civil or criminal.
Ms. Watts, you mentioned one of the practical differences between the two, and I think another one that we run into a lot of the time is particularly in a case like this. So you've got a father who has a good income and is paying a lot of child support and is not doing something, well, sure, he could be held in criminal contempt, and let's say the judge puts him in jail for 30 days and he loses his job. And then he says, oh, well, guess what? Now I can't pay child support. One of the other big reasons probably that people don't ask for criminal contempt.
Right. That's true. That's true. Don't want them to lose their job because then they can't pay support is pretty common, I think, for that. And I also want to address a few of the cases that Appellee cited for the proposition that it's fine not to tell in advance as long as once the hearing starts, if the hearing's done properly, that if it's criminal, you have criminal safeguards in place. And the two main cases there that they talk about are Bishop and Hicks. And both of these cases were decided in 1988, which was before the December 99 and the July 2000 contempt statute changes that changed the way contempt was done and said you can no longer be held in both. That was the 99. And then the 2000 was the change saying you can't start a hearing for one and then decide it's another. When Bishops and Hicks were decided, you guys would get something for review and have to look at, you'd have to look at it kind of backwards. You'd have to say what was ordered, and is that in the nature of civil or criminal? Okay, it's a civil order or a criminal order. So were the proper procedures employed, knowing now at the back end that it was civil or criminal? And it's kind of still happening that way. That we're looking at the end, and I think you see that in this order too. And one of the arguments that I talk about in the brief is it doesn't feel like the judge is quite sure in the remedy, if it's really civil, if it's really criminal. It's kind of this hybrid, best of both worlds sort of thing. And it feels like what's happening is this is the way we've always done it. And we've been doing it this way since before 99 and 2000. We just throw it all out there. And the cases that say that's fine before the statute said it wasn't.
Ms. Watts, let me ask you this. Can the court order a party to buy a telephone or an iPad?
To buy a telephone or an iPad? You mean as part of contempt, or like if the...
Well, let's say, no, the order is you got to buy a telephone, you got to give your children access to a telephone or iPad. Is that a valid order for a judge to order someone to buy something other than health care insurance?
I think, just off the top of my head, my opinion is you can order somebody to make them available communication, but you cannot order somebody to buy the equipment necessary. If I have to buy the equipment necessary to do it, then that's what I have to do. But I mean, I don't know the judge could say, go out and, spend $1,000 on an iPad, so that your children can do FaceTime. But I think it could say, make the children available for either virtual or telephonic communication. And then you figure out, how to do that. I mean, here, I think the children there was already an iPad, and it was ordered to make sure it was charged and ready and hooked up. I don't know if that completely answered your question or.
But I just wondered, if someone doesn't own a cell phone, someone maybe just has a landline, or someone has a flip phone. It doesn't have, internet capability or visual capability. Can the court order them to go out and buy a different phone beyond what they have? Or even if they don't have one at all?
I don't think that a court could do that. And I would have hoped at the trial, the testimony would have been, I have a landline, I don't have a smartphone. And so sure, telephonic communication can happen, but I have no way to do, video communication.
As I recall, wasn't this, I may be wrong, but wasn't this a consent order that set up the FaceTime and the communication provisions? So, I mean, the parties had agreed to,
Yes.
we're going to do it this way in this case.
Right. And he did already have the hardware.
Have the equipment.
Yes. So,
Well, and if I could ask you just to, the purge conditions, and if you want to say more about the due process argument, you certainly can, but, of course, I think the difficulty or the other in your next issue, of course, is the purge conditions that are set, and how does he actually purge? And so if you could address that.
well, the purge conditions are incredibly confusing. And with these two dates, this April 10th and this April 12th, and honestly, I think part of that date discrepancy has to do with, I think the hearing was originally scheduled for the 12th, got moved to the 10th, or vice versa, and all the dates didn't get, that's what I suspect happened, that it was all supposed to be one day, come to hearing, and then report to jail that same day, and that somehow the final edit didn't get fixed that way. But I guess the main problem I have with purge conditions is the judge says, standing right here, if I put you in jail right now, you don't have the ability to actually set these things up. And so let's stop and go home and do it, and then come back and see if you've done it. And I don't think that's how contempt's supposed to work. If you're in civil contempt, you go to jail until you purge, but you only go to jail if you have the present ability to purge to avoid jail. So if I don't have,
would that be any different than, let's say that let's say it's a money case, and of course, if he's smart, he would have brought his money with him.
right?
But let's say that he didn't, and the judge says, okay, can you get your $500 right now? And he says, yes, but I have to run across the street to the bank. Would there be a problem with the judge giving him the opportunity to run across the street to the bank and get that money to pay that purge? Because obviously he can't make the money appear magically right there.
Right. I assume
is that really any different? Let him run and get the money?
No. I could say that feels different, and I don't know where I would say a line is, but that seems like court is still in session. And I'm going to let you and the bailiff walk downstairs to where the ATM machine is, and you can walk across the street, as opposed to.
This is a very, very lenient judge who says, I'm going to let you go home and get the money out of your safe and come back Monday. How about that?
That's feeling less like it's comporting with the statutes. It really is. But like I said, I don't know exactly where that line is, but just personally, I feel good about it's the same session. Court's not over versus, days and days or weeks, come back on April 10th and see if you're in compliance. And if you're not, then 2 days later, you're going to go to jail. We don't know on April 12th if you can purge to avoid jail. We know that 2 days before you hadn't, but we don't know the day you report to jail if you have. And I wasn't involved at the trial level, so I don't know what all went into crafting this decree and these purge conditions and why they're, just honestly a little weird. I feel like they're a little weird in how they approach it. And she's probably trying to be nice and help him out and say, go get this done. There's no reason for you to go to jail right this second. But it made a mess. It really made a mess. So I've got my 5-minute timer popping up there. If you guys do not have any more questions on what we've already talked about, I'll be quiet until my rebuttal time.
All right, Mr. Odom?
With the law firm of James McElroy and Deal, and I'm here with my law partner Haley White, who will we hope to provide the argument today. The plan is for me to focus on addressing the issues with respect to the pre-hearing notice for the contempt hearing and the show cause hearing. And then Ms. White, when she argues, will focus on why the contempt order that was entered was valid substantively, including those purge conditions that Your Honor was just asking questions about. So with respect to the notice requirement, the appellant leans heavily on the statutory changes that happened back in 1999 and 2000. Under prior law, a person could be held in civil and criminal contempt for the same conduct. And under the prior version of 5A-23G, the trial court could start a civil contempt hearing and at the end hold that person in criminal contempt. That's what 5A-23G used to say. The statutory changes that occurred was to say that a person could not be held in civil and criminal contempt for the same conduct. And it says found in civil and criminal contempt for the same conduct. It doesn't say charged, can't be charged with criminal and civil contempt for the same conduct. Doesn't say cannot be tried for civil and criminal contempt for the same conduct. It only says found. And that's important. Professor Reynolds in her treatise talks about the difference between found and charged, and in talking about family law specifically, and recognizes that a party can be charged with both, but cannot be found in both. And so
would that necessarily mean that the same conduct would not violate both? If you cannot be found to have violated both, doesn't that mean the same conduct cannot constitute either or both?
No, Your Honor. My opinion is that you cannot have two different remedies for the same and elect those two different remedies for the same conduct. For example, in a general civil case, the same conduct can give rise to various claims. You could have a Chapter 75 claim arising from the same conduct, or you have a fraud claim, and you could get punitive damages on the fraud claim. At the end of the trial, the prevailing party, let's say it's the plaintiff in this instance, can elect to receive treble damages under the Chapter 75 claim and eschew the punitive damages for the fraud claim. You can't get a double recovery. And so the civil and criminal contempt in this context, I believe, is different remedies for the same wrong. The willful noncompliance with the underlying court order is central to both criminal and civil contempt. There is no difference in that respect. The same conduct gives rise to civil and criminal contempt. Where the distinctions lie are the coercive nature of civil contempt, where someone is still in continuing noncompliance at the time of the hearing, and you are able to coerce that party to comply going forward by way of purge conditions. And just as we believe what happened here with respect to the FaceTime provision.
Can I ask a question?
Yes, Your Honor.
So if you are charged with certain conduct, okay, it's your contention that could be civil and criminal. You can be charged with it, but only found for one, right? How is the nature of a civil versus a criminal hearing different? Or is it going to be the exact same procedure, such that you have to prepare differently for one or the other?
Your Honor, so if you're proceeding with a combined proceeding, where you have both civil and criminal contempt that are potential remedies for the same underlying conduct, then I believe that the Bishop case, which cites the U.S. Supreme Court's case in Hicks versus Fiat, it says that where you have that, the proceeding has to proceed as if it is criminal, and all the criminals, the safeguards that go with a criminal proceeding have to apply. And so in that instance, here we have an order to show cause. And in the typical setting in civil, that then shifts the burden of proof to the alleged contemnor to show why they are not in contempt. But if you're having a combined proceeding, then that order to show cause can only function as the criminal indictment, so to speak. And the alleged contemnor can't be compelled to testify. And so you have all of these safeguards in place. But then at the end, you can have civil contempt imposed as a remedy. You've met the heightened standards that would apply in a criminal setting, and there's no due process problem at all to hold that person in civil contempt at the end. And that brings us back to the statutory change to 5A-23G, where the law used to allow you to start as civil and then have criminal contempt imposed at the end. And that doesn't comport with the process of and the safeguards for criminal proceedings. And the General Assembly, when it changed that statute, didn't say that you can't have a trial on both together, which it could have easily done. It just repeated what it had already done in 5A-21 and said you cannot be found in civil and criminal contempt for the same conduct.
Would you agree that the burden of proof is different between the two?
Yes, Your Honor, the burden of proof is different. With respect to the criminal, the party would have to prove beyond a reasonable doubt. And with respect to civil, the party would have to prove beyond a preponderance of the evidence, or by a preponderance of the evidence. And that's what happened in the State versus Rebels case, where this court affirmed a finding of civil and criminal contempt arising from one proceeding, and the trial court appropriately made the findings based on the respective burdens of proof that had been met. And so this court has already given its imprimatur to that type of proceeding happening. In Rebels, we had distinct conduct, but arising from different violations of the same order or same orders. There was a TRO and a preliminary injunction there, just as we do here. One order violated in different ways. So thinking about one instance in this case where it might be appropriate to pursue just criminal contempt, the failure to timely notify the father's failure to timely notify my client of a change of address. There was a notification. It was untimely. It happened long ago. So that was the type of one-off situation where it's reasonable to suggest that criminal contempt would be the remedy for that.
Let me ask you this, would you agree that a criminal contempt, if you're seeking that there is a prior notice requirement to put the defendant on notice of that might not apply as much to a civil contempt?
Yes, Your Honor. The criminal contempt statutes say that the order to show cause that has to issue from the court has to be given a reasonable time before the hearing. That the trial court has to give reasonable notice by way of the order to show cause, and that happened in this case. It said that it was on January 10th when the order to show cause issued. And it said that there's probable cause to believe that a civil and or criminal contempt have occurred. And for Mr. Blanchard to appear on February the 2nd, over a month later, and show cause why he shouldn't be held in contempt. And the materials that we cited in our brief from Mr. Kroll at the School of Government that the other side actually cited at the trial court level says that where the trial court issues an order to show cause and identifies both possibilities of contempt, that is sufficient. And so we contend that when you're faced with this type of order to show cause that says that you can be held in either or both, that you prepare as if criminal might be on the table, and you have adequate notice of that. Which takes me to a point with respect to.
Let me ask you this before you move to there.
Yes,
if a defendant is charged with criminal contempt, would not he be entitled to a motion for a bill of particulars to more specify the conduct of which he's being charged with?
Your Honor, I actually think that's built into the criminal contempt statutes. 5A dash, let me look it up here, right here real quick. 5A dash 15, which deals with plenary proceedings for criminal contempt. Subsection C says the person ordered to show cause may move to dismiss the order. And the order it's talking about is the order to show cause. And,
right.
And so that, and there's also that same possibility with respect to a motion, an order to show cause for civil contempt under 5A.
So that would be like a motion for a more definite statement, would it not?
Yes, Your Honor, but with respect to the order to show cause, not with respect to the underlying motion upon which the order to show cause issued. And so I think that takes me to an issue preservation point. Mr. Blanchard moved to dismiss or for a more definite statement solely with respect to the underlying motion upon which the order to show cause issued. He did not move to dismiss the order to show cause. He did not appeal from what he says up until oral argument. I thought that they were contending that the order to show cause was defective because it didn't say one way or the other whether it was going to be civil or criminal contempt. Ms. Watson in her argument says that we're not challenging the order to show cause. It's fine. We're challenging the underlying motion. And so by not moving to dismiss the order to show cause or appealing from the order to show cause, we submit that Mr. Blanchard has failed to preserve any constitutional challenge for appellate review.
And you don't think the order to show cause is subsumed within the motion for contempt?
I think it references the motion, but I think it supersedes the motion. If there weren't an order to show cause, then we would be moving forward and could only move forward with respect to civil contempt, because you can't go forward with criminal contempt if it's just on a motion. And the issuance of the order to show cause has other implications, with most specifically shifting the burden of proof in the civil context. And so,
Well, and if I could just clarify that in this particular case, at the very beginning of the hearing, it was limited to just two paragraphs, 5 and 6 of the motion, and only as to civil, basically because of time constraints. And the other allegations were to be dealt with later. Is that correct?
that's right, Your Honor. That's correct. So, going back to the order to show cause and not appealing from it, it's similar to, we say in our brief, the Smith versus Smith case, where Judge Tyson, you were on that panel. In that case, there was an ED judgment that awarded passive appreciation on a retirement account to the cross-appellant wife in that case. My client filed a Rule 5259 motion, and based on what had happened in the pretrial order, said, hey, passive appreciation is something that's been dealt with. It can't be awarded as it's awarded in the original ED judgment. The trial court agreed with my client, entered an order granting the Rule 52 and 59 relief, and then entered an amended ED judgment. The cross-appellant appealed only from the amended ED judgment and not the underlying order that granted the relief, the Rule 52 and 59 relief that resulted in the entry of the amended ED judgment. And this court said that by not appealing from that order, you failed to preserve any challenge to the amended ED judgment on this particular issue. And we would say the same holds true here, where the contempt order resulted from a show cause hearing that came about by way of an order to show cause. And you don't appeal from the underlying order to show cause, and you haven't preserved a challenge for appellate review. And so that's, just wanted to address that issue preservation argument.
Let me be sure that actually order of contempt itself, it's on page 183 of the record. You're not contending that the defendant has not properly appealed from that order, correct? The actual order itself.
That's correct, Your Honor. They appropriately appealed pursuant to Rule 3 from the ultimate order, RE civil contempt. That's right. Before I turn it over to Ms. White, I just wanted to emphasize we're talking about contempt, and contempt is a mechanism for the enforcement of court orders. And we have the kind of three different types of contempt. You've got direct criminal, you've got indirect criminal, and you've got civil. And all of those remedies are meant to incentivize litigants to comply with court orders. They just go about it in different ways. And so the argument about that Ms. Watts made about, well, if somebody moves for criminal and civil and they really want to have the coercive remedy of civil, and in this instance, to be able to have FaceTime contact with the minor children. Similar to what we're looking at here, we're on video actually having an oral argument. That to have someone have to pick at least 5 days before the hearing, and then have someone then come into compliance and then say, hey, I can't be punished for what I've done. That just ties the hand of the trial court in trying to enforce its own orders. It's there's a passage from one of the cases cited in the briefs in the Bennett versus Bennett case. And in that situation, it was a little different because the contemptor had lost his job and wasn't able to pay the support necessary at the time of the hearing. But an important point this court made in that case, I think holds true here. And let me just read this one little passage. It says, Past contempt cannot be ignored by the court, even if at the exact time of the contempt hearing, the defendant does not have means to comply. A defendant may not deliberately divest himself of his property and in effect pauperize himself for appearance at a hearing for contempt and thereby escape punishment because he is at that time unable to comply with the court order. So our argument is that until the end of the contempt hearing, a court ought to have at its disposal both civil and criminal contempt, such that parties can't escape the consequences of their past disobedience of a court order by either divesting themselves of assets or the ability to comply with the court order at the time of the hearing, or by coming into compliance at the time. And Ms. Watts mentioned the possibility of having attorney's fees awarded in this type of instance. Well, that's remedial in nature. That goes to providing reimbursement for the person who had to file the motion and bring the contempt to begin with. But that's not punishing the person for disobeying the court's order. And so again, contempt is a mechanism for the court to enforce its own orders. And we think that the whole panoply of options ought to be available until the time at the end of the hearing where the election of remedies has to occur.
Mr. Odom, I want to clear up one thing. If you look at page 183 of the record, that's the order that's appealed from.
Yes, Your Honor.
First paragraph of there says that it is before the court on plaintiff's mother's motion for contempt. Now, you're saying that the appeal is not proper because the order to show cause was not appealed for. In this kind of situation, doesn't the order to show cause merely serve as kind of a summons to bring you into court?
I think I think in this type of situation, it's a finding by a court. In this case, it was a finding by a different district court judge, Judge Mann, that there was sufficient gravity to the motion, the verified motion, that the court said that Mr. Blanchard had to show up and show cause why he shouldn't be held in contempt. And so,
But once you get him there, isn't that subsumed in this order? This order doesn't mention the order to show cause whatsoever.
it actually does in finding of fact number 6, Your Honor, on page 184. It says on January 10th, 2019, the court entered an order to show cause. And then it goes into detail as to what the order to show cause said. So this was a show cause hearing that was conducted based on the issuance of an order to show cause.
Okay,
So-
is there any issue in the motion to show cause that was not subsumed in this hearing and in this order?
I don't understand your question, Your Honor. I'm sorry.
Is there any issue before the court that is not addressed in this order, the one that's appealed from?
Well, there were, let me say 2 things. Number 1, there were issues raised in the motion for an order to show, or motion for contempt, that weren't dealt with, that remain pending, as Judge Stroud noted. But with respect to how things went about at the February 12th show cause, this order deals with everything that was before the court on that day.
Thank you.
Thank you, Your Honor. I'm going to turn it over to Ms. White if that's, I'm sorry, Judge Collins, you have something?
I do. I'm talking on mute. Sorry about that. So we're talking about the order to show cause on page 162. Isn't that interlocutory? Wouldn't, if that had been appealed from and come up here on that, wouldn't we have said, we'll go back and let's see if you're found in contempt, and if you're not, then there's nothing to appeal?
I think that would have been true had there been an immediate appeal from that. But the reason it's not immediately appealable is because you can appeal it after entry of the ultimate contempt ruling.
So I think that goes to Judge Tyson's, though, when we're talking about what's subsumed and what can be inferred, at least in the notice of appeal and the actual order that you're appealing from. Wouldn't that completely subsume this order to show cause, basically? such that you wouldn't have to reference it specifically.
Well, Your Honor, I would contend that you have to actually reference, just like in a civil case, where if there was an order, granting a motion to dismiss, and then there was an ultimate final judgment, you would still need to designate in the notice of appeal the order that granted the motion to dismiss one of that party's claims, or else it would be abandoned. So our contention is that you would still need to designate that prior interlocutory order as part of your appeal from the ultimate contempt ruling. And actually, the case law too says, in this instance, contempt rulings often are interlocutory in and of themselves, but are appealable because they affect a substantial right. In this instance, there are no other claims that remain pending, such that this would have been the final judgment of the case. There was a motion to modify custody that had been filed by Mr. Blanchard, but was later dismissed. But there were none of the underlying claims were still pending at the time of the entry of the contempt ruling. So our position is that pursuant to Appellate Rule 3D, that you would need to list the order to show cause in this instance to preserve the argument for appeal. Any other questions? All right, thank you. I'm going to turn it over to Ms. White.
Thank you.
And I'm going to give Ms. White a couple extra minutes since we had so many questions there. I know y'all were trying to split this up a little bit better, so maybe 3 additional minutes.
Thank you, Your Honor. Please support Haley White. I am Mr. Odom's co-counsel, and I also represent Ms. Blanchard. The trial court here appropriately held Mr. Blanchard in civil contempt because Mr. Blanchard was not in compliance with the custody order on the day of the hearing. The custody order required the custodial parent to provide the non-custodial parent with 15 minutes of phone or FaceTime contact each evening. And the evidence showed that from the time the custody order was entered in November 2015 up until April 2018, when Mr. Blanchard was remarried, Ms. Blanchard did have that FaceTime contact with the children. In April 2018, Mr. Blanchard blocked Ms. Blanchard from his cell phone, thereby eliminating the main means of contact that Ms. Blanchard had with the children, and said, here's an iPad contact information. You can use this to contact the children. Mr. Blanchard argues that he was in compliance at the date of the hearing, and the issue is whether the trial court believed, and we contend the trial court didn't believe based on the findings and the evidence presented, that Mr. Blanchard's act of taking the iPad out of the drawer and turning it on for 30 minutes in the evening without telling Ms. Blanchard that she should call during that time, and without taking any steps to facilitate those phone calls, was actually in compliance with the order. Blanchard relies on finding of fact 17 in the order as evidence of his compliance, but finding of fact 17 is not a finding of compliance. It is merely a small but essentially meaningless step towards compliance when you consider the evidence that was before the trial court. And that evidence was you had from April 2018 up until the hearing, 8 to 9 months of an absolute refusal to allow the FaceTime conduct. You had repeated requests from Ms. Blanchard via email, via text message, please allow me to FaceTime. I would like to FaceTime my kids, not receiving a response. Numerous letters from Ms. Blanchard's attorneys to Mr. Blanchard's trial counsel, again, not having received a response. There was evidence presented that from May 2018 to September 2018, Ms. Blanchard attempted to call the iPad from her cell phone 64 times and not a single call was answered or returned. You had evidence at the trial court that beginning in September 2018, Ms. Blanchard actually no longer had the ability to call the iPad from her cell phone. And a screenshot showing that Ms. Blanchard was unable to call the iPad from her phone was admitted into evidence, and that's documentary exhibit number 25. Ms. Blanchard made Mr. Blanchard aware of the issue no less than 5 times from September all the way to December 2018. And that evidence was before the trial court as well. You also had evidence that the weekend just prior to the hearing, which was the last time that the children were in Mr. Blanchard's care, that Ms. Blanchard was not provided with the FaceTime or the phone contact with the children. So over a period of about 9 months, you only had 3 calls that Ms. Blanchard was allowed, despite an order that requires nightly calls, and despite all of Ms. Blanchard's efforts to effectuate the calls. This is similar to the Best versus Gallup case, where this court upheld a finding of civil contempt, where the mother was found to be interfering in the phone contact when she had control of the phone, and less than half of the calls from the father to the mother's cell phone went unanswered. It's also similar to the Deans versus Deans case, where a mother was found in civil contempt for interfering with phone contact when she only answered 5 of the father's calls out of 200 over a year and a half. It's similar to another case, Wilson versus Ginyard, which is a published case where a father was habitually late to custodial exchanges, and he was found in civil contempt for that. Moving on to the next issue, the trial court here set proper, definite, specific purge conditions which allowed Mr. Blanchard to purge his contempt. These purge conditions do not modify the custody order. They just simply specify how Mr. Blanchard is supposed to allow the FaceTime contact. And after a period of 8 to 9 months, the trial court, in my opinion, she took very great lengths to explain to him how he was supposed to make this happen to ensure that it happened. There are several cases that we cited in our brief that support our contention that these are not modifications, but they're simply just specifications of how the phone contact should happen. And again, that's the Wilson versus Ginyard case, the Tankala case, and the Best versus Gallup case. The Best versus Gallup case, there were purge conditions which set out specific times for a defendant to ensure telephone access when the underlying custody order didn't specify those times, and that was not a modification of the custody order. The purge conditions set a definite date by which Mr. Blanchard's purge would be complete. The plain language of the order makes clear that April 10th is the initial date by which his purge, by which could have purged his contempt, and that's in Decretal paragraph 5.
Yeah, let me ask you about this date. So
Yeah.
they had the hearing February 12th, is that right? Is that right?
There was, what Ms. Watts referred to earlier is what happened. It was a scheduling. So when we were in court, April 12th was the date that the review hearing was supposed to happen. And then after that, it got rescheduled. There's a scheduling difficulty. And then April 10th ended up being the date. But the language of the order, to me, it specifies an initial date, an initial hearing date on April 10th, and then another hearing date before Mr. Blanchard is to be taken into custody, because the order makes clear that he's going to have an opportunity to speak to what he's done to purge himself of the contempt prior to being taken into custody. So if he hasn't done it on the 10th, he has one more opportunity between the 10th and the 12th to purge it.
And that was entered on, I guess, April 2nd, based on the file stamp date. So
Yes.
as of April 2nd, he was ordered to have the review by the 10th, and then assuming all went well, he would not be reporting in jail on the 12th.
Yes, Your Honor. So there was an issue with the recusal, and it took a little longer than we would have liked to get the order entered, but he would have had to, from April 12th to April 10th, make the children available to Ms. Blanchard for FaceTime or phone contact.
And then that's basically his purge is over at that point. He does that, he's purged.
Correct.
Which I think is different from a lot of the cases. I mean, the ones we typically, the ones that have been reversed, have said basically, okay, continue to comply with the order, which of course never ends. Or So this,
Correct.
basically, he's done what he had to do to purge by that date.
60 days or 10 days. 60 days from the court, the ruling, but 10 days from the date of the order. And then the trial court also did not order Mr. Blanchard to report to jail on April 12th, regardless of whether he was in compliance. Again, the order made clear that there would have been a hearing prior to him being taken into custody about whether he had complied or not, and any arguments of inability to comply could be addressed at that time.
Ms. White, let me ask you this. Had the defendant just notified your client that, look, don't call my phone, but I'm going to turn on the iPad between 6 and 6:30 if you want to call the children, would that have been sufficient?
Yes, Your Honor, if that notification would have happened and she would have been able to connect her phone to the iPad, that was another problem, is that she didn't have the ability after September to even call the iPad. So if there would have been that notification and then some further step to ensure that there were no technical difficulties, then that would have been sufficient.
So if he turns the iPad on and does not do anything to prevent her from calling, has he done everything that he can at that point? I mean, must he affirmatively assure that that she makes the connection?
Well, Your Honor, what he did have was email after email after email of her saying, I cannot call the iPad. I have no way to contact them. So yes, I think if he knows that, if he knows that she can't connect with the iPad, just turning the iPad on is not sufficient. He knows there's a problem and he's done nothing to rectify it.
So the fact that he could have kept her blocked from the cell phone would not itself be contempt. Is that correct? As long as she could access to the iPad.
Not correct. As long as there's another means of communication, yes.
Because obviously he didn't want her calling his phone.
Obviously.
I mean, there's plenty of testimony of that.
Yes, Your Honor.
So your complaint is she had no access.
Correct.
To children.
He was in control of the access and she had no way to access the children.
Okay. I'm just trying to get to what level of affirmative assistance that he would have to do to ensure that her call went through. If he's got it charged and he turns it on and makes it available to him, is that enough? And you're saying no.
I think if the purge conditions that specify just how he's supposed to ensure that she can connect to the iPad, I think that's enough. But I think when he has knowledge that she cannot connect to the iPad and she was in her emails days and days and days, I can't connect to the iPad. So when he doesn't take that affirmative step to make sure that she can connect, I think that he's in violation.
Okay, thank you.
Thank you.
And I don't think, there were so challenged, I think those findings of fact about that by the trial court, right?
Correct, yes.
Those are pretty clearly established. All right, thank you. And we'll move back to Ms. Watts. And you had a lot of questions too, so I will, if we need to do any additional time, we can look at that.
I don't think I have a lot to say, so we'll see once I'm saying it if it ends up being a lot. One thing Mr. Odom said is that until the end of the hearing, the judge should have at her disposal both civil and contempt remedies, and cited, I don't remember if it was Bishop or one of those older cases for that. The problem with that, and he said, you go in and you just treat it like a criminal hearing, and you give them all the safeguards. And so that's okay. But that's not okay because the Kim Tim Noor is doing a criminal hearing where he chooses not to testify. And then the judge says, I hold you in civil contempt. Well, if we had been doing a civil contempt hearing, the alleged Kim Tim Noor would have testified and said, here's the 15,000 pieces of proof I have that I'm not in contempt, but I didn't take the stand because we're pursuing this criminal. So that,
Well, I agree, but now in this particular hearing at the outset, it was already limited to civil based upon two particular allegations. So we don't, that is certainly a problem that could happen, but it didn't happen here.
right. And that did not exactly happen here, but it was part of this argument about why you shouldn't have to alert ahead of time, because it can be fixed at the end, and that it can't, because then I've pled my Fifth Amendment right to not incriminate myself, and I've messed up my civil contempt hearing. So I do want to say that. And then the issue of the show cause order that Judge Tyson and Judge Collins were asking if that shows cause order was subsumed. And, you know, 1-278 does say that the intermediate interlocutory orders affecting the merits, affecting the judgment, can be reviewed. That statute itself does not say that you have to file a separate notice of appeal from those prior interlocutory orders that affect the issues, affect the judgment. So for what that's worth, just on the statute, it appears that yes, you can look at that if that show cause order becomes an issue. And then lastly, I'll just respond to something, just to clarify something Ms. White said about the times that appellee called and couldn't get through and the 6 to 6:30. There was a point before the hearing that he did say 6 to 6:30 is when I am going to have this on, and she knew 6 to 6:30 was the time. There was no testimony that I saw whether in that 2 weeks before the hearing she tried to call during that window and could not. There was a lot of testimony that she tried to call before that notification and could not because he didn't have it on during that whatever window. So we don't know if once he said, here is the window, I will have it on, if she tried and did not get through. And so we don't know if she did or she didn't. So kind of for that's worth it, that is part of my argument that he actually was in compliance because he gave her the discrete time period that she could call and he would have it available. And there was no evidence that he did not actually follow through with that after he provided notice.
Yeah. And, yeah, this is sort of neither here nor there, I guess. But if these people aren't already on our family wizard, I hope they get there. But anyway, yes. You don't have to answer that. But
that's good. So I guess I really did not have a lot to say. I was correct. So unless you guys have any questions, I will stop talking.
Why don't you tell us what relief you'd like the court to grant?
I would like you to vacate the show cause order, and I would like you to hold that due process requires that the alleged contemnor be provided with notice at least 5 days ahead of the hearing, which allegations are being pursued as civil and which allegations are being pursued as criminal. So I do want you to get into the due process issues, but at a minimum, I want the order vacated. And so I guess that's it.
okay. Anything else? All right. Well, thank y'all very much for your arguments, and thank you for. I think things went reasonably well with our technology, so did that. All right. So we will adjourn, and we do have a special session for a swearing in immediately after this. So the judges will hang around to participate in that.
Thank you.
Thank you.
Thank you, Your Honors.
Court will be in recess until approximately 3:30.